The Supreme Court just dropped a nuclear bomb on Keir Starmer's government, and what they've uncovered is absolutely explosive. While you were sleeping, while you were going about your daily life, your Prime Minister was secretly orchestrating the biggest betrayal of British democracy since the original Brexit referendum. We're talking about a covert plan to drag the United Kingdom back into the clutches of the European Union through the back door, completely bypassing Parliament, completely ignoring the will of 17.4 million Leave voters. And the evidence that just emerged in this ruling is so damning, so utterly scandalous, that it makes Watergate look like a parking ticket. The Supreme Court justices didn't just strike down Starmer's scheme, they absolutely eviscerated it, calling out the deception, the constitutional violations and the brazen attempt to overturn Brexit without anyone noticing. This isn't speculation anymore. This isn't conspiracy theory territory. This is cold, hard, legal fact delivered from the highest court in the land. And what's been revealed in the last 60 minutes will shake British politics to its very core. The documents that surfaced during this Supreme Court hearing paint a picture so disturbing that even hardened political analysts are struggling to process it. For the past 18 months, while Keir Starmer stood at the dispatch box promising to respect the Brexit referendum result, promising to make Brexit work, promising that Britain's independence was secure, his government was simultaneously running a parallel operation designed to systematically dismantle every single Brexit achievement. We're talking about secret negotiations with Brussels that bypassed normal diplomatic channels entirely. We're talking about draft treaties that would have surrendered British sovereignty over trade policy, fishing rights and border control. We're talking about binding agreements that would have locked the UK into EU regulations for decades to come. Agreements that were being crafted in complete darkness, away from parliamentary scrutiny, away from media attention, away from the British people who voted for independence. The Supreme Court obtained these documents through a whistleblower case brought by three former Brexit negotiators who couldn't stomach what they were witnessing inside Whitehall. These weren't junior civil servants, these were senior figures who had worked on the original Brexit withdrawal agreement under previous governments. And what they discovered made their blood run cold. According to the testimony that's now public record, Starmer's team established what they called a reset implementation unit in early 2024, housed within the Cabinet Office but operating with almost no oversight. This unit's sole purpose was to identify mechanisms for EU regulatory realignment that could be implemented without triggering formal treaty obligations that would require parliamentary approval. Read that again slowly. They were specifically looking for ways to rejoin the EU's orbit without having to tell Parliament or the public what they were doing. The legal framework they were attempting to exploit is genuinely diabolical in its cleverness. Instead of negotiating a single comprehensive treaty that would obviously signal a return to EU jurisdiction, they were planning to implement dozens of smaller sectoral agreements, each one individually insignificant enough to avoid scrutiny, but collectively amounting to full regulatory convergence with Brussels. The Supreme Court identified agreements covering everything from chemical standards to digital services, from food safety to financial regulation, from environmental policy to workers' rights. Each agreement would contain what the documents called mutual recognition clauses and dynamic alignment provisions. In plain English, that means whatever rules Brussels decided to implement, Britain would automatically adopt them without any vote, without any debate, without any democratic input whatsoever. The UK would become a rule taker once again, but this time without even having a seat at the table when those rules were being written. But here's where it gets absolutely infuriating. Here's where the betrayal becomes so brazen that it's almost hard to believe. The Supreme Court uncovered internal government communications showing that Starmer's advisors were fully aware this strategy was constitutionally questionable at best and potentially illegal at worst. There are emails, there are memos, there are meeting minutes where government lawyers explicitly warned that this approach might violate the principles established in the original Brexit legislation. And the response from Starmer's political team was essentially to find more creative ways to hide what they were doing. One email from a senior Downing Street advisor literally says, and this is a direct quote from the court documents, "We need to ensure these arrangements are embedded before opposition can mobilise. Once implementation begins, reversal becomes politically impossible regardless of legal challenges." Let that sink in. They knew they were on shaky legal ground. They knew they were subverting democratic process. And their solution was to move faster and hide better, so that by the time anyone noticed, it would be too late to stop them. The fishing rights component of this scheme is particularly galling because it strikes at the heart of what Brexit was supposed to achieve. British fishing communities were told that leaving the EU meant taking back control of UK waters, that British fishermen would finally have access to the resources that had been given away under the hated Common Fisheries policy. The 2020 Brexit deal secured significant improvements for British fishing. Not perfect, but a genuine step toward reclaiming sovereignty over our maritime territory. The documents revealed in this court case show that Starmer's government was negotiating a new fisheries framework that would have gradually returned quota allocations back to pre-Brexit levels over a 15-year period. British fishermen would have been slowly squeezed out of their own waters again, and the mechanism was designed to be so gradual, so technical, so buried in bureaucratic language that most people wouldn't understand what was happening until it was already done. These coastal communities that voted overwhelmingly for Brexit, that were promised a brighter future, were being set up for yet another betrayal. And the people orchestrating it were counting on the complexity of fisheries management to keep the public confused and disengaged. The trade policy dimension of this conspiracy is equally shocking and demonstrates just how comprehensively Starmer was planning to surrender the advantages that Brexit provided. One of the key benefits of leaving the EU was the ability to negotiate independent trade agreements with partners around the world. Deals tailored to British interests rather than having to accommodate the protectionist instincts of French farmers or German manufacturers. The UK has successfully negotiated trade agreements with Australia, with countries across Asia, with partners in the Americas, agreements that simply wouldn't have been possible inside the EU framework. These deals represent billions in potential economic activity and position Britain as a global trading nation rather than a regional bloc member. The Supreme Court documents reveal that the Reset Implementation Unit was developing a customs cooperation agreement with Brussels that would have effectively neutered Britain's ability to maintain these independent trade relationships. The proposed agreement contained most favoured nation clauses that would have required the UK to extend any tariff reductions negotiated with third countries to EU imports as well, completely undermining the competitive advantage of British trade deals. Even more disturbing, the agreement included regulatory equivalence requirements for goods that would make it virtually impossible for Britain to accept products from non-EU countries unless they met EU standards. On paper, this sounds reasonable, but in practice, it means that Britain couldn't import American beef or Australian agricultural products or New Zealand dairy without forcing those countries to comply with EU regulations that they don't apply to their own domestic markets. This is the exact trap that Switzerland fell into with its bilateral agreements with Brussels, a situation that Swiss politicians have complained about for years because it gives them the worst of both worlds, no influence over EU rules, but still bound to follow them. Britain fought for 5 years to escape this type of arrangement. Millions of people voted specifically to avoid becoming a vassal state, and Starmer was planning to walk right back into the same cage through a series of technical agreements that he hoped nobody would fully understand until it was too late. The timeline that the Supreme Court exposed makes it clear this wasn't some theoretical long-term possibility. This was an active plan with concrete implementation deadlines. According to the internal documents, the government was aiming to have the foundational agreements signed by mid-2025 with regulatory alignment beginning to take effect throughout 2026 and 2027. By the time of the next general election, scheduled for 2029, Starmer was counting on having created so many bureaucratic and commercial ties to Brussels that any future government would find it economically and administratively impossible to to unwind them. This is the same strategy that was used to entrench EU membership in the first place over decades, creating such deep integration that extraction became incredibly difficult and painful. The British people rejected that approach when they voted for Brexit. They explicitly chose short-term disruption over long-term subjugation, and Starmer's plan was to ignore that democratic mandate entirely and rebuild the cage while pretending to respect their decision. The constitutional implications of this scheme are truly staggering and strike at the foundations of British democracy. The principle of parliamentary sovereignty, the idea that Parliament is the supreme legal authority and that no Parliament can bind its successors, is one of the core pillars of the UK Constitution. The Brexit legislation passed by Parliament specifically required that future governments maintain UK sovereignty and not cede power back to EU institutions without explicit parliamentary approval. The Supreme Court ruling makes it abundantly clear that Starmer's network of sectoral agreements would have violated this requirement in both letter and spirit. The justices point out that while each individual agreement might not appear to constitute a major constitutional change, the cumulative effect would be to restore EU primacy over vast swathes of British law and policy. And because these agreements were being negotiated and implemented through executive action rather than primary legislation, Parliament was being systematically excluded from decisions that would fundamentally alter Britain's relationship with Europe. Justice Henderson's opinion, which forms part of the majority ruling, includes language that is extraordinarily harsh by the normally restrained standards of judicial writing. He states that the government's approach represents a troubling contempt for parliamentary process and democratic accountability. He notes that ministers have a duty to be transparent with Parliament about the constitutional significance of international agreements, and that this duty was not merely neglected, but actively subverted through deliberate obscuration and misdirection. These aren't criticisms about minor procedural irregularities. This is the Supreme Court essentially accusing the government of lying to Parliament and the public about what they were doing. In the entire history of modern British politics, it's difficult to find another example of the judiciary delivering such a damning assessment of government conduct. Even during the height of the prorogation controversy in 2019, the court's criticism was more measured and focused on specific legal errors, rather than questioning the fundamental good faith of the government's actions. The public reaction to this ruling has been absolutely explosive, and we're only in the first few hours since the judgment was published. Social media is on fire with Brexit supporters expressing a mixture of vindication and fury. Vindication that their suspicions about Starmer's true intentions were correct. Fury that the betrayal was even more comprehensive than they imagined. The hashtag Brexit Betrayal has been trending at #1 for the past 3 hours with over 500,000 posts. Reform UK leader Nigel Farage held an emergency press conference within 30 minutes of the ruling being published, calling for Starmer's immediate resignation and stating that this is the most serious constitutional crisis Britain has faced in living memory. He's demanding that Parliament be recalled from any recess to hold an emergency debate and that criminal investigations be launched into whether government officials committed misconduct in public office. Conservative leadership candidates have been scrambling to respond, with several calling this conclusive proof that Labour cannot be trusted on Brexit and that the Conservative Party must make defending British sovereignty the absolute centrepiece of its political identity going forward. But it's not just politicians and political activists who are outraged. Ordinary people who voted Leave back in 2016 are expressing a sense of betrayal that goes beyond normal political disappointment. These are people who were told they were paranoid for thinking that the establishment would try to reverse Brexit through the back door. People who were mocked and ridiculed for suggesting that Remain politicians would never truly accept the referendum result. And now they have official confirmation from the Supreme Court that their instincts were absolutely correct, that there really was a conspiracy at the highest levels of government to undo Brexit while pretending to respect it. The fishing communities in Cornwall and Scotland are particularly vocal, with representatives stating that they feel like they've been stabbed in the back by people who smile to their faces while preparing to sell them out to Brussels yet again. One fisherman interviewed by the Bee said he felt physically sick reading the details of the proposed fisheries agreement, that after everything his community had been through, after all the promises, they were going to be betrayed. Once more by politicians who view them as expendable pawns in a larger game. The European Union's response has been notably quiet so far, which is telling in itself. Normally, Brussels is quick to comment on major political developments in member states and former member states, but as of this moment, there's been no official statement from the Commission or from any senior EU officials. This silence likely reflects genuine surprise and embarrassment that their confidential negotiations with the UK government have been exposed in such spectacular fashion. It's one thing for there to be rumours and speculation about secret talks. It's quite another for detailed documentary evidence to be placed on the public record by a Supreme Court ruling. EU officials must be scrambling to figure out how to respond without either confirming that they were complicit in an attempt to subvert British democracy or throwing the Starmer government under the bus and damaging future relationships with the UK. Either way, this revelation has seriously complicated Brussels' hopes for a smooth reset of UK-EU relations and has handed enormous ammunition to Eurosceptic parties across the continent who will use this as evidence that the EU cannot be trusted and that it actively works to undermine democratic decisions it doesn't like. The immediate political implications for Starmer's government are potentially catastrophic. His approval ratings were already declining due to various domestic policy controversies. But this is on an entirely different scale. This isn't about disagreements over tax policy or healthcare funding. This is about fundamental honesty and respect for democracy. When a Prime Minister is caught by the Supreme Court attempting to overturn the result of the largest democratic exercise in British history through deception and constitutional sleight of hand, the damage to his credibility is almost impossible to repair. There are already rumours circulating in Westminster that several Labour backbenchers are privately expressing concerns about Starmer's leadership, though none have yet gone public with calls for him to resign. The political calculation for these MPs is incredibly difficult because turning on their own leader would trigger chaos within the party and potentially hand power back to the Conservatives. But continuing to defend Starmer after this ruling requires them to effectively endorse his attempt to subvert Brexit, which would be politically toxic in many of their constituencies. The legal ramifications of this ruling extend far beyond just blocking Starmer's specific plans. The Supreme Court has now established clear precedent about what governments can and cannot do regarding EU relations without parliamentary approval. Any future attempt to deepen ties with Brussels, whether by Labour or by any other party, will now face immediate legal challenges based on the principles established in this judgment. The court has effectively created a constitutional firewall protecting Brexit that cannot be dismantled through executive action or bureaucratic manoeuvring. This is actually a remarkable example of the judiciary defending democratic decision-making against governmental overreach. There are people who will criticise the court for being too political or for exceeding its proper role, but the judgment itself is meticulously grounded in constitutional law and parliamentary sovereignty. The justices aren't imposing their own policy preferences, they're enforcing the principle that when the British people make a fundamental decision about their constitutional arrangements through a referendum, and when Parliament enacts that decision through legislation, the government cannot simply ignore or reverse that decision without going back to Parliament for authorisation.